On August 6th, the Justice Department found that Duke Law School intentionally discriminated by race in admissions across three straight entering classes. And their evidence was LSAT scores. So the government built a federal civil rights case out of the same number you're studying for right now. Of course, Duke says they are reviewing the letter, and no court has ruled on any of this yet. And that fight belongs to the lawyers. I'm not going to debate the details here. But what I can tell you is what's in those documents and what they do for your application. Two things to watch for as we go through this. First, there is a number in the government's own table that almost nobody is quoting, and it goes against the story everybody's telling about this letter. I'll show you what that is. And 11 days after that letter went out, the Department of Justice opened up a second front about scholarship money involving full rides at a law school, and that, of course, affects your scholarship money. Let's start with what actually happened. On April 18th, 2025, the Civil Rights Division opened up a compliance review of Duke Law's admissions. In December, they asked for more. So Duke had to hand over internal emails, admissions committee memos, reviewer training modules, and applicant level data going back to the 2018-2019 cycle. Then just a few weeks ago on August 6th, the department sent back its findings, signed by Harmeet Dillon, who runs the Civil Rights Division. Their finding was that Duke Law intentionally discriminated by race in admissions for the incoming classes of 2023, 2024, and 2025, a violation of Title VI of the Civil Rights Act, read through the Supreme Court's 2023 decision in Students for Fair Admissions. And Duke's public response was 2 sentences long. The university is reviewing the letter, and it's committed to complying with the law in a way that is consistent with its academic mission. That is the whole thing. Now, of course, after the 2023 Supreme Court decision, law schools could not consider race directly, and so every admissions office in the country had the same problem. What do they do now? And Duke's answer, according to the letter, involved tags. Applicants wrote short answer essays about how they would further the school's mission. Reviewers reading those essays were told to tag what they found. One of those tags was diversity/services. Reviewers were also told to tag other things about the applicant's background, including, for example, whether the applicant had received a Pell Grant. And of course, a tag is just a checkbox. It doesn't say race on it. Duke's published policy said reviewers never saw racial demographic data, and the letter, of course, doesn't dispute that. The department's argument is that those tags correlate with race closely enough to stand in for it. Their phrase is material race-related proxies. Dillon's phrase for the whole setup is ostensibly race-neutral tools. Now, of course, correlation is not identity, it's not determinative, and most Pell recipients in the country are actually white. There are, of course, plenty of first-generation applicants who are also white. And so whether a correlation gets close enough to legally count as a proxy is exactly the question that no court has answered yet. The claim, stripped down to the bare bones, though, is that Duke built a process where nobody had to look directly at race, but race was found out anyway. That is the theory. Now, here's the data it rests on. According to Duke's own applicant files, as summarized by the department, the 2024 cycle looked like this. Among admitted applicants, the median LSAT score for Black applicants was a 164. For white applicants, it was a 172. For Asian applicants, 173. Now, the median LSAT among denied white applicants was 167. Among denied Asian applicants was 168. And so the middle of the rejected pile sat above the middle of one accepted group. 2025, same deal, same direction. Admitted Black students median of 166, denied white and Asian medians of 168 and 169. Now, every one of those is a group median. A median does not describe an individual. Half the group is above it, half the group is below it, which means there were admitted Black applicants at Duke well north of 164, and denied Asian applicants well under 168. Nobody's individual files in those numbers. But in that same 2024 cycle, the admitted median for Hispanic applicants was a 170. In 2025, it was a 171. And so a 170 is higher than both denied medians, higher than the 167 and higher than the 168. If the tags were quietly doing the work of race across the board, the number should look like the 164, but it doesn't. It's up there with the white and Asian admins. So whatever was going on inside that process, it wasn't one clean, simple thing happening the same way to every group. It's not a clean story. Now, the department also ran a statistical model on the 2025 applicants using three inputs: LSAT, undergraduate GPA, and race. And according to their model, it estimated that a Black applicant had roughly 3.5 times the admission probability of an equally strong Asian applicant. Now, two things about that 3.5 times prediction. It is the government's estimate from the government's own model. Duke did not publish that. They did not agree to it. And the model only had those three things. Duke's actual admissions process also has essays, rec letters, work history, and maybe other miscellaneous factors. If you leave all of that out, the race variable is supposedly carrying whatever they didn't measure. So this is underspecified. It's not showing the full picture. Now, Duke's own ABA 509 report for the class that started in 2025 says their 25th percentile LSAT was a 169, median LSAT 171, 75th percentile 172, median GPA of 391. They took over 6,000 applications, made about 800 offers, so they have about a 13% acceptance rate. Now, most people read 169 to 172, and here you need at least a 169. But that is not what those numbers say. The 25th percentile means 1 in 4 enrolled students scored below 169. Duke enrolled 227 first years that fall, and so roughly 55 of them came in under a 169, and Duke doesn't publish how far under. Now, those 509 percentiles cover enrolled students, and the DOJ's figures cover admitted applicants, which are two different pools. Apples and oranges to some extent, but they do still both point to the same thing. The published band is narrower than the actual class, and a number on the stats page is a summary of a process nobody outside admissions actually sees. And a lot of people talk themselves out of applying based on a number that was never actually the cutoff. Which brings me to the internal record where people tend to get a bit careless. I want to be careful here. In November 2023, Duke Law's Associate Dean for Admissions and Student Affairs wrote to a colleague about how the school should describe its diversity work publicly. And the letter quotes him, quote, "I'd prefer not to say that we will have to work harder to enroll a diverse class. This is true, but I don't want folks to think we didn't work harder if and when the class is not as diverse as we would like." Now, the worry being described in that email is not the policy itself, it's about how the policy will be described. Now, I'm not going to tell you what he meant because I don't know, and neither does anybody reading one sentence pulled out of an internal document. But here's what I will say. That is an ordinary internal email about messaging, and now it's got a federal document number stamped on it. Every dean in the country read it and thought about their own outbox. Now, I want to be fair to Duke here because this matters and almost nobody online is doing it. Those excerpts were selected by the party building the case, the DOJ, and those are out of thousands of pages. Anybody's work email would look bad under that scrutiny. Duke hasn't yet had their turn to defend their case, and plenty of serious people read that same letter and conclude Duke did nothing wrong, and the government is the one out of bounds. I'm not going to settle that in this video right now. But I will say the letter also cites an annual memo to the dean that counted the fall 2023 entering class by race, 27 Latino students, 23 Black students, 67 Asian students. And I've seen people online hold that up as a smoking gun, but it's not. Every ABA accredited law school counts the racial composition of their entering class because the ABA requires it. Duke publishes those counts. Counting after people enroll is not a violation, and it never was. Now, the DOJ's actual claim is narrower and harder to prove. It's that the tags let race back into the application read on the front end before anybody enrolled. Now, Duke says reviewers never saw race, and that is the real fight, and that's the one you want to watch if you're following this story. But there's something for you in this either way, regardless of who wins. For years, applicants have been sold this story of holistic admissions, that files are read in whole. Your number is one factor among many. We see you as a person, and there is some truth to that. But the process described in this letter, the picture of how Duke actually reviews applications, is a lot more mechanical. There's the mission statement, hypothetically, but then you've got tags, categories, templates telling reviewers what to flag and how to contextualize a weaker academic record. None of that is illegal on its face, but it is contrary to what the marketing brochures describe. Now, there is a second front about money. On August 17th, 11 days after the Duke letter, the Civil Rights Division opened a compliance review of the College of William and Mary, and this one's about scholarships. The notice names 2 law school programs: the Lemon Legal Scholars Program, which offers up to 5 full-ride scholarships, tuition, and fees, that the department says appear to be earmarked exclusively for graduates of historically Black colleges and universities. There's also the Reaching Back Scholarship, which is need-based, with a stated preference for HBCU graduates or applicants who contribute to the school's diversity. The department says it has reached no conclusions. It just opened up a review, so don't assume the worst. I'm just describing it straightforwardly. And the department has also opened admissions investigations at 15 medical schools on top of earlier findings involving medical schools at Yale and inside the UC system. They are running school by school. Now, here's my read on what happens next. I'm flagging this as a read. It's just a prediction, not a fact. If you were a dean who just watched a peer school's internal emails turn up in a federal findings letter with document numbers attached, you don't wait for Duke's case to resolve. You call up your general counsel that afternoon, and your general counsel goes through your admissions process and your scholarship criteria and pulls out anything a lawyer could stand up in a deposition and call a proxy. So I want you to watch application forms this cycle. Watch the essay prompts. Some of them are going to get shorter and blander, and nobody's going to put out a press release about it. What survives that conversation is what a school can defend in writing: their test scores, their grades, written criteria that apply the same way to every applicant, anything a stranger can audit line by line. I would call that the defensible file. The parts of your application a school can point to 3 years from now and explain on paper to somebody who definitely is not on their side. And the scholarship half of this is the part everybody underrates, so let's talk about that. Duke Law's sticker tuition for 2025 was over $80,000 for just 1 year. Across 3 years, you're past $240,000 in tuition alone before you've paid rent or eaten anything, and that assumes tuition holds flat, which it hasn't at Duke for any year I've looked at. Now, in 2025, 94.4% of Duke Law students received federal grant money, fewer than 6% paid sticker. So, sticker price at a school like this is a starting number that almost nobody actually pays. Almost everybody gets a discount. The question is, how big is your discount? And schools determine the discount based largely off of your highest LSAT score and your GPA. At these prices, a few points of difference is tens of thousands of dollars in scholarship money, and towards the top of the range, it clears 6 figures across 3 years. That is your entire 20s. It's whether you could take the public interest job you wrote about in your personal statement, or whether the loan payment picks your career for you. And if scholarship criteria that used to run in the background gets scrubbed out, the money doesn't evaporate. Of course, somebody still gets it. My read is it lands on whatever criteria survives the lawyer conversation, and those criteria are numbers, your LSAT, and your GPA. And before I go further, keep in mind, of course, I sell LSAT prep, and so when I tell you the LSAT just got more important, take it with a grain of salt. Go read the documents yourself. They're short. You don't need me to interpret them for you. Now, I can't show you or prove that a findings letter will make your score count more. Nobody can yet. No school has published a revised rubric, and none of them are going to. But keep in mind that LSAT scores do carry their own large racial gaps. A general counsel could look at this letter and conclude the safest move is to generate fewer auditable numeric disparities, not more. That's a real potential reading. So the narrow claim is that written criteria are easier to explain to a stranger than judgment calls are. Your LSAT score is the most objective number in your file. That's a reason to take it seriously, which still leaves you in the same place. Your GPA is probably a done deal. If you've graduated college, that number is final and nothing's going to change it. Your story, of course, still counts, not saying it doesn't. But what's changing is that the people reading it are about to get a lot more careful about writing down why they weighed it the way they did. But regardless, you can increase your LSAT score if you studied the right way. That part is still in your hands. And I'd rather you spend the next 3 months on that than on your resume. Keep in mind, logical reasoning is now 2/3 of your score. If your score is stuck, logical reasoning is typically where it is stuck. And so next time you review your mistakes, ask yourself not just why is the right answer right, because then you just read the explanation, you feel good about it, and you move on. Do the opposite. Take the wrong answer choice you just picked and explain what would have to be true for that choice to be correct. And if you want my help navigating that kind of review process, getting down to the root cause of why you're getting things wrong, what could you do differently the next time around, I'm happy to help you out. I'm offering free LSAT tutoring for everybody watching this now or later. You can book that free tutoring lesson with me at unpluggedprep.com/start. The link is below the video on YouTube, pinned in the chat on YouTube, in my bio on TikTok and IG. I've also put together a free LSAT cheat sheet to help you jumpstart your LSAT prep. It's a quick reference PDF on everything logical reasoning and reading comp. You can grab that free PDF at unpluggedprep.com/cheat sheet. On August 17th, the Justice Department opened a civil rights investigation into how the College of William and Mary hands out scholarship money. 5 different programs got named, 2 of them are at the law school, and the school has until September 8th to turn over the records. Now, you might be thinking this is unique to Virginia. What does it have to do with you if you're outside Virginia? But there is a date attached to those 2 law school programs that turns this from a story about one school into a story about the last 6 years of law school financial aid. On August 17th, the Civil Rights Division of the Justice Department opens what's called a compliance review into the College of William and Mary. Press release 26-937. That notice letter is public. You can read it yourself. The legal hook is the Title VI of the Civil Rights Act of 1964. If you take federal money, you cannot discriminate on race, color, or national origin. William and Mary takes federal money, so the government gets to look. This is not really a lawsuit so much as it is an audit with real consequences, because nobody's been sued, nobody's been charged. The press release says in plain language that the Civil Rights Division has not reached any conclusions about the subject matter of its investigation. William and Mary put out a statement saying they are committed to non-discriminatory learning environments and to complying with state and federal law, declined to comment further. Now, what a compliance review does is it demands documents. If the DOJ eventually decides there's a violation and can't reach an agreement with the school, the escalation runs into a federal civil suit and to cutting off federal funding. That is the pressure behind the date. Quote from Assistant Attorney General Harmy Dillon, quote, "Awarding scholarships or offering coveted opportunities to students based on the color of their skin is illegal and offends the guarantees of our colorblind institution. The department will not turn a blind eye to race-based preferences, quote, however they are packaged or portrayed by universities." However they are packaged. So that covers a lot more than a checkbox on an application. It covers whatever a school built around one. Now, like I said, 5 programs got named. 3 of them sit outside the law school. There's an undergraduate scholarship, which doesn't affect you, of course. The 2 that matter to you are at William and Mary Law specifically. The first is the Lemon Legal Scholars Program. The Justice Department describes it as up to 5 full-ride scholarships, tuition and fees, that appear to be earmarked exclusively for graduates of historically Black colleges and universities. Recipients also get one-on-one academic advising, bar exam planning, networking, and access to events with faculty and senior administrators. Now, there's a small thing I saw here. The DOJ says up to 5. The law school's page says at least 5. Those are not the same commitment. That's just my LSAT brain working overtime here. The document review will, of course, sort all of that out. The second one is the Reaching Back Scholarship, which is need-based scholarship with a stated preference for HBCU graduates or for applicants who contribute to the diversity of the law school. Now, William and Mary, founded in 1693, is, of course, not an HBCU. The eligibility criterion here is about where the applicant already graduated from, not a fact about the applicant directly. Now, I assumed this was a post-2023 workaround. The Supreme Court rules on race-conscious admissions. Schools lose the direct route. Schools get clever and rebuild the same thing. Appointed institutions instead of at individuals. But that's not what happened here. The Lemon Legal Scholars Program was announced in 2021, came out of an initiative the law school launched in 2020, which came out of a task force from 2019. The Lemon Project it's named for goes all the way back to 2009. All of that predates the Supreme Court ruling. And so the DOJ is not chasing somebody's clever 2024 rewrite. They opened up a category law schools spent most of a decade building up, back when everyone involved believed the institutional criterion sat on solid ground precisely because it was not an individual one. That's what, quote, however they are packaged means in practice. The age of the structure does not protect it. Now, an HBCU is an institution. Anybody of any background can enroll at one and graduate from one, and plenty of people do. Schools running these programs have said out loud they're recruiting from a college the way they might recruit from a service academy. Now, I'm not going to tell you what I think about this because you're not here for my opinion. What we're here for is how to get you the best law school outcomes possible, how to get you as much scholarship money as possible. So I want to look at what's going on with scholarships here. Now, William & Mary is the third Virginia public university pulled into a federal civil rights investigation since last year. The University of Virginia was the first with 5 open investigations. Those got suspended after UVA reached an agreement with the Justice Department, and that agreement runs through December 31st, 2028. As long as the school stays in compliance. George Mason was the second. Their review is still open. Now, I don't think William & Mary is going to fight this all the way to the wall. They are a public school with federal funding on the table. And UVA already showed what a settlement looks like. The most likely outcome, in my opinion, is that the eligibility language gets rewritten so no institution and no group is named, and the money keeps moving under a criterion that survives review. Now, what survives review? I'll try to get there if I can, but I want you to see what happens to the money here. Because every ABA accredited law school files a document called the Standard 509 Information Report. It's public, it's only 4 pages long, it's a simple table that you can read easily. Most applicants never open one. I read all of them every year. In William & Mary's 2024 filing, 93.6% of its students were getting grant or scholarship money. Nearly everybody. In the entire school, only 34 students were paying full price. In the 2025 filing, that number is 65.9%. That's a big difference. About 94 out of every 100 were getting scholarships, now down to only 66 out of every 100. The count of students paying full sticker went from 34 all the way up to 176, 5 times as many people writing the entire check. Now, a 28-point swing in 1 year could mean a school changed their aid strategy. It could also mean a school changed what counts as a grant. The 509 report doesn't tell me which. All it gives us is a head count, and head counts are hard to reinterpret. What we can say as well is that the number getting more than full tuition went from 11 up to 25, more than doubled. Now, more than full tuition means the school covers everything and then gives you money on top of it. Now, fewer students on the one end getting anything at all. The ones who do get a lot more. Now, non-resident tuition at William & Mary is nearly $63,000 a year. In-state is about $39,000 a year. So for everybody else, that's roughly $189,000 in tuition alone, which goes up most years, so treat that as the floor. One more thing here as well. The drop shows up in a filing predating the letter. The DOJ did not cause that drop, which means the squeeze on the scholarship money was already happening before any of this hits the news. So I want you to look this up yourself if you're considering this school or any other that could be affected. Search the school's name plus Standard 509. Every accredited school has one and it's a public PDF. Pull up the LSAT table first, 25th percentile, median, 75th. The median is the number the school protects. Anything above it pulls that number up, and they're going to pay you for helping them out in the rankings. At the 75th, they're going to pay a lot. If you're below the median, you're dragging them down, which leads you to have to pay more money. Then there's the grant table. It splits the student body into bands: no grant, less than half tuition, half to full, full, more than full. Count the number of people in each band. That tells you whether you're applying to a school that spreads the money evenly across everybody or concentrates it on a few. Totally different bets. Then look at conditional scholarships, which ones are guaranteed versus which ones could be reduced or eliminated based on where you fall in the class. Now, US News ranks law schools on 10 things. Employment outcomes and bar passage together are 58% of the score, and a dean cannot touch any one this year because those numbers are based on who they admitted 3 or 4 years back. Median LSAT is only 5% of the ranking, but it is predictive of the other two. And so the inputs determine outputs. In other words, who they admit based on LSAT then determines later who's more likely to pass the bar, who's more likely to get a job. Which means that the LSAT scores they admit determine what scholarship money they pay to help them raise in their rankings. Now, I can't prove why schools admit certain applicants and who they're going to give scholarship money to, but the US News rankings help to determine what deans are going to do because they set up the incentives. William Mary's LSAT median went from 164 to 166 in a single year. Part of that is money. Part of that's because applications jumped up from about 1,500 up to 2,200 in a single year, while the acceptance rate dropped from 32% to 22%. When you have a lot more people applying, medians go up very easily. Now, applicants for this past cycle were up 8.2% over the year before, up 28.2% compared to 2 years ago. Over 75,000 people applied to at least one law school. The 4-year average before this was only 59,000. So there was more competition, higher bars, less scholarship money spread across the class, and what's left of it goes to the top of the score range. That's bad news for most applicants. I'm not going to sugarcoat it. Plenty of people watching this will pay full sticker at a school that would have discounted them 3 years ago. But if you've already graduated college, while you can't change your GPA, what you can affect is your LSAT score. Law schools do not average multiple LSAT scores. They only take into consideration the highest LSAT score on your record. And so if you want the best and easiest path forward to get into better schools, to get more scholarship money, none of this changes what you should do. Retake the LSAT, get a higher score, incentivize the schools to give you more scholarships, put yourself in a better negotiating position. If you want my help getting a higher LSAT score, getting into better schools, I'm happy to help you out. I'm offering free LSAT tutoring for everybody watching this now or later. You can book that free tutoring lesson with me at unpluggedprep.com/start. The link is below the video on YouTube, pinned in the chat on YouTube, in my bio on TikTok and IG. I've also put together a free LSAT cheat sheet to help you jumpstart your LSAT prep. Free PDF download. You can grab it at unpluggedprep.com/cheat sheet. In the meantime, all the best. Take care. Thanks for joining.